Welcome to A Lawyer's Guide to the Galaxy, a podcast about geek culture by lawyers, with your hosts, Ben Siders and Kirk Damon. This episode is sponsored by Heisenberg's Pet Emporium. We have cats. We also don't have cats. Stop in and see for yourself.
And welcome to episode 5 of the Lawyer's Guide to the Galaxy. I am your host, Ben. With me here, as always, is your other host, Kirk. Kirk, say hi to the people.
Hi to the people. And once again, that's Kirk, as in the captain of the Enterprise.
Yes, indeed. So, Kirk, what's up? How you doing, man?
Doing pretty good. So I've heard today we're going to talk about what's happening tomorrow.
Yes. We're going to talk today about what's happening tomorrow and what people 30 years from now did 10 years ago.
Okay. And that is indeed that today's episode is going to be talking about time travel.
Yes.
Because time travel is a huge amount of fun.
Yes, indeed. Now, let me ask you a question. Have you heard of a warp engine?
Of course, I've heard of a warp engine.
And do you know how it works?
Yeah, you put these big nacelles in the back of a spacecraft, and Scotty tells you whether or not you're going to blow them up.
Broad strokes, we warp space-time, and then the vessel it's attached to moves forward,
Exactly.
Right? How about transporters?
Yep, definitely heard about transporters.
And what do they do?
Transporters take you from one place and move you to another, and the doctors don't like to use them because they've experienced them way too much.
And how do they do this, right? Like, what's the underlying technology?
The underlying technology, and I think they went through this in one of the episodes, is basically they sort of convert you to code, transmit the code, and then reformulate you.
Yeah, right.
It's a fancy 3D printer, so to speak.
Basically, you get disintegrated and then transmitted to somewhere else and reassembled.
Yep,
which, if you think about it, that means you die every time you transport.
Exactly, and I think that's one of the issues that's always kind of amusing about transporters, and one of the things they've gotten into is, does anybody really actually want this technology to come true?
And how about cloaking devices? You know how those work?
Oh yeah, definitely. The cloaking devices is what allows the Romulans to just simply show up in their lovely little wavy form on the front of the screen.
Yeah, and technically all you're doing is bending light waves around a device, and if you've been paying attention to the internet for the last, since it's existed, you've seen people trying to invent these things. So some of the stuff we've talked about actually exists. How about transparent aluminum?
Oh yeah, transparent aluminum is a staple in conjunction of Star Trek at this point in time.
Yeah, and there actually is such a thing. It's I looked it up right before we started. It's called aluminum oxynitride. It's a transparent ceramic that's actually been around for like 15 years.
Yep.
So some of this stuff that like we've found out about in Star Trek, or mostly Star Trek, but in geek culture has been the genesis for people trying to invent these things. I just read about, I think it's called quantum tweezers. It's some sort of microscopic level tractor beam type technology. And what we're going to talk about today is, could you patent this stuff?
I think an interesting thing just to talk about is the idea that, when we're talking about this sort of Star Trek technology and stuff that's technology going forward, if we go back in time, you can bump into this. I actually just happened to be on board the Intrepid Museum out in New York City, and one of the ones they talk about, and we went through a space presentation, they go through Jules Verne's spacecraft, and the spacecraft that existed, long before humans had any form of space travel, before in many respects we even really had flight, and powered flight was something that was common. And you look through what these were, and one of the things they talk about is how it encouraged people, and it sort of the science fiction became a genesis to move forward. And one of the ones he really talked about is you look at some of the original spacecraft, and they had no concept of the idea of vacuum, of needing spacesuits. These things are basically studies in space. There's great discussion. They have dogs with them, sort of stuff like that. All the tools they need, which includes pickaxes and things along those lines. But one of the ones that was really interesting, they actually talked about a film that came out where it was a German film, and it actually came out, and it basically sort of implies using a rocket. And when World War II started, it was actually suppressed because of the fact that they didn't want people thinking about the fact that rockets could potentially be used to do this. The reason being is because one of the consultants they had on it was one of the great rocket scientists. And that's actually where he'd come up with the idea of using a rocket to get to the moon. So there's some really interesting sort of things, even if you go back in time, of science fiction encouraging actual innovation.
So what we're going to talk about today is related to that, and it's how does it work when, and this is going to be presented as a hypothetical, but it's not. Suppose a time traveler from the future, say the 2030s, comes back to our time and brings with him or her the plans for a futuristic device. This is actually a plot device in a number of Star Trek episodes, or at least one I can think of, and then tries to get IP rights to what they brought back, basically taking future technology back to the past and then trying to enrich yourself on it. Believe it or not, this has happened, and this application has been filed with the Patent Office, and so we know what will happen. So this is one of the few episodes where we're going to have an answer to the question. Now, to understand this, you need some background on how this happened, because not is all as it seems.
And I'm going to let Ben tell the story, because he knows this story much better than I do.
I actually followed this when it was going on. So cast your mind back to the 2000 U.S. presidential election. We're talking about Bush v. Gore, Florida's up for grabs, litigation is flying. It's like November, January. And a guy starts posting on bulletin boards. And if for those of you who are under a certain age, namely our age, you may not know what a bulletin board is, but these would be old text-based BBSs back in the day.
It is sort of a bulletin board is to Facebook what you can say a garage sale is to eBay.
Yeah, but believe it or not, there was social networking before Facebook, and this is what it was. So this is the year 2000 when Google didn't have a search engine yet. And this guy was posting on BBSs claiming to be a time traveler from the year 2036. He said he was a soldier from Florida sent back in time to recover an IBM 5100 mini computer to deal with the Unix 2038 problem, which, if you don't know, is an elaborate, much more complex version of the Y2K problem. The short version is the way Unix tracks time. In 2038, it will run out of bits and flip back over, and your Unix machines will all think it's like 1912.
And of course, if you remember the Y2K bug, that'll result in apocalypse, which obviously it did.
Yeah, this problem's pretty much all been fixed by 64-bit operating systems, and it really only lives now in old embedded systems. So if, just so you know, and you heard it here first, if in 2038 you are still using an old embedded Linux system you got in the late 90s, it will break. Okay. So anyway, the guy on the internet told a very elaborate story about coming civil strife resulting in the United States splitting into 5 districts. If this sounds like a series of movies you've heard lately, I'm sure that's a coincidence. Culminating in a short but violent World War III in 2015, which obviously did not happen. This is, in my opinion, a bunch of nonsense, and everybody who isn't a tinfoil hat conspiracy nut should have realized that at the time. Regardless, the poster, he went by the name John, I don't know how it's pronounced, Titor or Titor, Titor. He has a Wikipedia page, so you can look him up. He was challenged as being a hoaxer by smart people, and he tried to prove his claims by posting on the internet diagrams of his General Electric Model C204 time displacement unit, and even explained a little bit how the physics worked. He basically said it's the EWG multiverse theory, and so all quantum states simultaneously exist somewhere within the superverse, which, as an aside, if he's right, that means that my alma mater, the University of Iowa Hawkeyes, have won 15 straight football championships in some alternate universe, and that's the universe I should have been born in.
Yeah, we know you'd like that to be true.
That would be great. Anyway, so Titor explained, he pulled a poochie and said he's going back to his own time, and then never posted anything again, and since he never asked for money or tried to sell anything, everybody assumed he was legit.
I presume he's also never been seen again. I don't know if anybody even knew who he actually was.
I don't think he has. And the fact that just the mere fact that he didn't try to sell anything as a threshold for credibility is an alarming statement about our society. But moving on. Fast forward to 2004. A guy named Marlon Pullman took Titor's schematics and his explanations of how the time machine worked and filed for a patent with the U.S. Patent Office. And you can actually look it up. It's application number 10/954767. We'll post that in the show notes. And it was published on April 6th of 2006. The Patent Office dutifully examined his application and issued a decision. And here's the question. Did he get a patent, and why or why not? And before we answer that, I'm going to warn you, there are some incredibly, I won't say dumb, but non-intuitive things that have been patented. Number one I can think of is Magic the Gathering. Turning a card sideways is, I think the patent just expired.
Kim Klein, I know it's getting close to as to what it is, but yeah, there's one of the things to keep in mind is that the patentability threshold requirements in many respects are very low. It simply requires something to be novel and non-obvious.
And useful. You can't patent garbage.
Yeah, you can't patent something which is completely non-useful. At the same time, it's one of those things where when you think about it as being novel and non-obvious does not necessarily mean it's practical, or does not necessarily mean it's something everybody's going to want. I mean, one of my favorite sort of, very old patents of things that is a little bit interesting is a method for waking people up silently. So instead of having an alarm that goes off and makes a lot of noise, it drops a pillow on your head. So
there's a guy that patented a new way to swing on a swing, like a way to swing sideways without having to actually move your upper torso.
Yep.
And the question is always, why does anybody want to patent this, and what do you do with infringers? And the answer is, who knows? It's probably just some
But the
crazy
real key question about it is the United States Patent and Trademark Office, when they're looking at this, is not going to really look at the fact of
they
is
don't
this
care
thing
about your
something that's
motivations.
useful, what's your motivations, or anything else. They're going to look at it and they're going to say, is it novel? Which basically means, is it new? Does it not exist previously?
And obviously, the time machine is new.
Yep, obviously the time machine is new. Is it non-obvious? Well, we obviously don't know how to do time travel at this point in time, so presumably it's also a non-obvious method for doing it.
Well, let's back up to where patent rights come from in the first place.
Yep.
So this is going to be one of the few times on this show I'm going to read to you from the law. But fortunately, it is the shortest possible statement of the law, and that's the U.S. Constitution. So our patent rights in our country, at least, are defined in the Constitution. If you're curious, Article 1, Section 8, Clause 8, also sometimes called the IP Clause. And it says, Congress has the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Pretty straightforward. And the key thing we're going to focus on there is securing two inventors. And that should be a hint as to how this case comes out. So to understand patents, you have to understand a little bit of the time frame in which they were established. The Patent Act, I think, was one of the first couple dozen things Congress did after the Revolution.
You keep in mind as well, what the section you just read is in the United States Constitution. This is not an amendment to the United States Constitution.
This is like the 1780s version.
Yeah, in the original Constitution. And so that tells you a lot of, that this was something that was very important. Now, it was obviously arising out of our English heritage. I mean, that's the reason why we had this, and many protections of patent and copyright arise out of England long before there is a United States.
And there's two ways to protect cool things at the time. One was, don't tell anybody.
Yep.
And the other one was, tell everybody. And don't tell anybody is called trade secret. This is where you ferret away your special technology. You don't tell anybody how it works or how to do it. And as long as nobody figures it out, you're the only one that can do it.
Trade secret is the formula for Coca-Cola. We're all familiar with
exactly, right? You can't patent, recipes for the most part. So Coca-Cola keeps that on lockdown. And if anybody else were to legally and independently figure out what's in Coke, they could make it. They can't call it Coke because of trademark, but they could make a chemically identical substance and sell it. Which would obviously erode Coca-Cola's market share.
Maybe.
So maybe, yeah. The formula, all these pharmaceutical generics are out there too, but people still pick up, the name brand that costs $1 more. So the downside to trade secrets is, if somebody else figures out what you're doing, then you kind of lose the IP protection. The upshot is they never expire. So as long as nobody figures it out, you're all set.
Trade secret is kind of an interesting thing because trade secret literally is sort of the law recognizing the ability of just, I'm going to keep something secret and that's okay.
Yeah. Yeah, and this is where corporate espionage comes from, too. And there's a whole separate legal regime called trade secret misappropriation. And, in fact, the federal government, I think last year, finally enacted a Federal Trade Secrets Act. But as a public policy matter, we don't really like trade secret. We think it's better that if important scientific and technical advances are discovered, they should be disclosed. So, way number 2 of protecting cool innovations is tell everybody, and that's what patents are. And conceptually, the patent is essentially a contract with the public that gives you a private right and eventually gives the public access to your technology.
One of the key things to keep in mind about patents is that they are a limited time, and that's actually one of the elements you specifically said in conjunction with that constitutional quote. Is the constitutional quote specifically says that it grants the power to promote it, the exclusive rights and their respective writings and discoveries. But one of the elements that you didn't specifically put in there is that it's for a limited time.
Yeah.
And that's a very important element in conjunction with a patent.
Particularly for patents, which are very short-lived. So those of you who know, copyrights last, for all practical purposes, forever.
Well,
right?
It's 70 years plus the life of the author.
Right. So if Kirk and I
time.
both have a heart attack and drop dead right now, this podcast enters a public domain in the 2080s.
Yeah. So that's, there's something with, in conjunction with that. Patents, on the other hand, have a term of 20 years from the day that they're filed. At least modern patents. Older patents actually had a term that was 17 years from the date they issued, but that changed back in the 90s, if I remember correctly.
By legal standards, it's a short amount of time. So, but to get a patent, in exchange for giving you this temporary monopoly on your invention, you are required to explain to the public everything about it. You have to tell us what it is, how to make it, how to use it, how it works. You have to basically provide a specification that enables us to make and practice your invention. The whole idea behind the patent is we get to rip you off, but in exchange, you get 20 years of exclusive use of the patent. So you have to jump through a lot of hoops to get a patent, and you have to tell us everything, and then it's going to be published to the public. So going back to John Teeter, what happened? Well, Here's what he claimed for his patent, and I'm going to read a little bit of this because it's actually pretty interesting. So he tried to patent a method for the generation of a pseudo 2+1 dimensional, I don't know how to pronounce all these words, anti-de Sitter space comprising, essentially creating two black holes, overlapping the event horizons, and creating a space-time bubble that lets you travel back in time. His explanation is about 400 words long, but that's basically what it is. Now the question, did he get the patent? Kirk?
I'm pretty sure he did.
Of course he did not. Now, there's two reasons why he didn't get it. One is the official reason that the Patent Office gave, but there's another reason that's even more interesting.
I think the thing that was really interesting to get into in conjunction with this is a lot of people would look at this and say, well, he doesn't get the patent because this thing doesn't really exist.
Which doesn't matter.
It doesn't matter. And that's a key thing to keep in mind is the Patent Office does not require you to have ever actually built your invention. It simply requires you to describe it in sufficient detail that somebody could build it.
So his first step is creating two Kerr-type positively charged rotating dilation singularities. Here's the problem. How?
Yeah.
Nowhere in his disclosure does he explain how to do it. There's no enabling disclosure. We don't have this technology. Now, this is another thing with patents. If everybody already knows how to do something, you don't have to explain it. So if I try to patent, something that involves using a web server, I don't have to explain how to set up a hypertext transfer protocol. It's just assumed that a person of ordinary skill in this technology area would know how to do that. However, we do not know how to create black holes. At least not yet.
We do know they exist at this point in time.
We know they exist. We don't know how to make one that does not also swallow the Earth, or make one, period. So his rejection he got was under a section called 112, which means that he did not provide an enabling disclosure, and so he cannot get the patent. But I think there's a more interesting reason why he should not have gotten it, and it is simply this: he didn't invent it.
Well, and that's, I think, the most interesting question you've got here. One of the key things we mentioned, and you said it right in the beginning of this, and I don't know if you guys caught it, Mr. Titor, or however you pronounce his name, did not file this patent application. Our time traveler himself did not actually file for the patent application. It was filed by another individual who took the schematics he brought back.
Yeah, and so I guess it's possible that the Titor hoax was perpetrated by Pullman. I don't know if that's true or not, in which case maybe Pullman did invent it.
They could basically be the same person, I suppose.
But here's the more interesting question. So what if Titor traveled back in time and then filed the application in his own name when he was like 2 years old?
Well, and we've sort of had something like this happen, if I remember right. Didn't this happen in like Star Trek 4?
Yes.
Where we actually go back and there's an issue in conjunction with the fact that they need transparent aluminum because they need to transport the whale to get it back. But of course, nobody knows how to make it. So they perform it, they put it on a computer.
That's right. Scotty gives the guy the chemical formula in exchange for the glass they need for the whale containment area.
And he makes it, and as you sort of see serendipitously, the guy hits save, in conjunction with it, and save the methodology. So you kind of bump into that of the idea that this is, almost directly, this sort of scenario is almost directly out of a Star Trek movie.
Yeah, it's pretty similar. Now, another interesting question. So if Titor filed it himself, and he was alive and he was the inventor, could you in theory get a patent on that?
You could in theory, although I think in this, John Titor himself is not really not the inventor because we talked about the fact that this is a GE device.
He claimed to be a soldier, and so GE would have owned the rights.
And especially when they say GE is becoming the umbrella corporation and is now a quasi-military organization, or pick your other favorite corporation which takes over the world in the distant dystopian future. That's not what he claimed. He simply claimed to be a soldier.
Yeah, exactly. So he didn't invent it either. So presumably, let's just indulge for a moment this fantasy that all of this was legit and Mr. Titor was telling the truth. So this means at some point in the future, GE invents a time machine, which,
somebody
by the way,
at GE, not GE,
somebody does, and GE acquires the rights. So buy your GE stock right now. The more interesting question is, what happens when GE goes to pursue this patent in the 2030s? Is this prior disclosure now prior art?
Yep, and that's the term prior art that you just heard Ben use, by the way, is you cannot patent anything which is known. As we mentioned, the idea has to be novel and non-obvious. Anything which occurs beforehand is referred to in patent lingo as prior art. So basically, anything which comes before when you file for your patent application is something which you have to be novel and non-obvious in light of. So the obvious danger is if you put something out there, you put a product on sale, then you later try to patent it, your product which is on sale can be prior art against you. And that's a gross oversimplification of sort of the way prior art works.
But it happens
a good way
all
to think
the time.
about it.
People come to us with something they want to patent, and they've already had it on sale for years in advance. They're like, well, now I finally have made enough money off my sales to patent it. Well, now it's too late.
And that's the issue we have here that's very interesting, is that we assume this is all true, we have somebody having filed this patent application to something that GE or somebody at GE will presumably invent a few years from now. So how do we deal with the fact that it already is out there in a patent application? A patent application, in some sense, is the best form of prior art there is, because we talked about that enablement piece and the idea that you have to have this disclosure which says, here's how to build it. We've told people how to build it. If this is now possible, presumably this patent application has told people how to build it.
Another thing, prior art references also have to be enabling. So if I was the lawyer in 2030, I'd say, well, we have an action from the patent office saying this was not an enabling disclosure, so it can't be good for prior art either.
Now, the problem with it is what wasn't enabled, though, is how to make the singularities.
So you'd have to claim the invention with more detail. Like, you'd have to get the patent on how you form the black hole rather than just the fact that you formed it.
Yep, and I think that's one of the issues that you bump into this, is you can look at this and say, assuming this methodology does actually work and this creates a time machine by overlapping two black holes, that's now actually been disclosed. Now, again, we're making an assumption that all of this is true, but you then bump into that may not be patentable to actually say we can make a time machine by overlapping two black holes. Even though it's not enabled in here, what's not enabled is how to make the black hole in the first place. So one could say that may be patentable.
And that goes back to our initial talk about warp drives and transporters, these things that are being invented now, and why, how come Star Trek, the original series, is not prior art as to warp drives. If all you were to claim in a patent is a warp drive, well, then it is prior art.
Yep.
But, you'd have to put into your patent application how you form the warp fields and all that kind of stuff, which means that the Star Trek disclosure, while it might be relevant prior art, you should probably put it on an information disclosure statement to the patent office, is probably not going to prevent you from getting a patent because it doesn't explain how it works.
Yeah, and that's a really interesting thing sort of when you get into science fiction, and particularly when you get into the idea of science fiction being prior art, is there's a lot of stuff which has explained how this stuff works. When you think about it, there's technical guides out there exactly about how a transporter works. And when you start getting into modern technologies that are created from it, you have the idea of how much of this actually is fiction and how much of it is science. There's a number of science fiction books out there where they go greatly into the science about how this could work. At the same time, they may leave an enabling step aside or one of those. Talking about time travel, and I think it's sort of a great example. One of the things I used to read a lot when I was a kid is Dean Koontz. And Dean Koontz's novels, one of the things I always liked is that most of his novels simply require you to make acceptance of certain things as being truth before you begin with the novel, and then the novel makes sense. And it's usually sort of a scientific truth. He writes one about time travel, a novel called Lightning. And one of the great things in conjunction with Lightning is how the time travel interacts with it. And the book makes sense if you accept the fact that time travel is simply possible and when it occurs and stuff along those lines. You get into the science behind a lot of these science fictions and this basic sort of assumption. You then get into, well, what happens when somebody makes the assumption true? We talked earlier about transporter and the idea of what a transporter is, and I made the reference that a transporter is effectively just a fancy 3D printer. In many respects, so is a Star Trek The Next Generation replicator. I mean, it's something which allows you to create food out of component molecules.
A holodeck's like a multi-directional conveyor belt and force fields.
Yeah, and people are making effectively, AR, augmented reality and virtual reality devices at this point in time, which use multi-directional treadmills, which use this kind of thing with it. Where do we get into the line between science fiction and not just science in this case, but actually innovation, and particularly when we're talking about patentable innovation?
Well, I think what it boils down to is scope, right? The more detail that's been previously disclosed, fictional or not, it doesn't matter if it doesn't work, right? It doesn't matter if the prior art is fake or made up. The bottom line is the disclosure is out there.
Yep.
And so and an interesting question to me is, if somebody happens to accidentally figure out, say some sci-fi author, exactly how to do all this stuff in enough detail, you could really narrow down the scope of future patent protection available to somebody who actually practices the invention.
Yeah, and that's I think the most interesting thing is as our science fiction and a lot of the science fiction that I think is becoming more and more popular is becoming more and more detailed on the science facts of it. And particularly certain authors are very into writing very detailed science facts.
And Trek in particular is a reason why a lot of our examples come from Star Trek, is the Trek producers always, I think, were famous for making a more concerted effort than most to get the science right, to at least use the correct terminology. I can't tell you how many scientific principles I first heard on Star Trek. I'll never forget tachyons I learned from The Next Generation.
Yep, and this kind of thing. And it is just an interesting interplay between the fiction and the reality. And as much as it was, our prior episode, we talked a lot about copyright and the interests of copyright and sort of things in fictional universe. Now we're talking about very real world things. We're not talking about something which somebody has created. We're talking about the interaction interaction of what somebody has simply created, and in some sense as a purposely fictional plot element, now coming into, no, this is a real world innovation and this is a real world change. And you get almost an intersection between the idea of the world that a science fiction author may wish to create or may wish not to create, depending on which author you're talking about, interacting with the world which is then being created in the future.
Well, there's one more possible resolution to this whole question of what happens if you come back in time and disclose. If the multiverse theory is correct and all quantum states exist in a superverse, then the grandfather paradox doesn't exist, right? So it's possible that what we're talking about is just the legal version of the grandfather paradox. So maybe in the future, a version where the prior art's disclosed, nobody ever invents the time machine. So it's not a problem.
And that's one of the great things that you sort of get into in conjunction with anything with time travel. And it's one of the ones that I've always liked when I review time travel, and it's, you read books on time travel. And one of the ones I'm just going to talk about is another Star Trek example. There's a great novel. It's one of the very first novels in the Star Trek novella series, which in high school I was addicted to. And the book's called The Entropy Effect. And one of the things I really love about The Entropy Effect, and if you haven't read it, spoiler alert, I'm going to give away a lot of the plot here, but there's a number of scenes which take place in it which are not real important in conjunction with it. There's a scene where Scotty goes chasing after Spock and can't figure out why he can't find him. And the reason that all these scenes happen is because Spock travels back in time. But it's very important that he's already been seen in all of these scenes by somebody as the course of the book. And so when you get into the idea of time travel, we bump into the scenario that basically says, have these things already happened? And so we look at the idea of saying, hey, it's not bad. Is it possible to patent the time machine? Has somebody already come back in time and removed the patent for the time machine? Has something changed the past already? And again, the Dean Koontz book I mentioned, Lightning, that's another one of the same sort of important stories, which is, in that one, it's the basic premise of it, and again, spoiler alert if you haven't read the book and want to, is it's created by Nazi Germany, and the guy who's coming back as a soldier, and he's actually jumping into the future, and the issue in conjunction with it is he wants to change the life of this person this woman that he's essentially fallen in love with, and has had a series of unfortunate events occur. And it starts off in the story with her having already encountered him repeated times. And that's an important element, is the fact that he's already there. He already exists sort of in the past before you find out anything in conjunction with the time travel. And I think that's one of the most interesting things in conjunction with it. And in conjunction with that book, and again, sort of a spoiler alert as to what it is, there's a key end as to why World War II ends. And the fact that basically this soldier on purpose ends World War II and creates the history we know in order to carry out what it is he's trying to do. So you bump into that problem of exactly how does time travel affect real world travel.
Another book along those lines, if anybody's interested in this kind of stuff, check out The Stars, My Destination by Alfred Bester. It's sort of an older book, but if you're interested in time travel paradoxes and general sci-fi stories, that's another good one. Well, I see we're short on time here, so we're going to wrap it up. So this, again, would be the part where we take questions, comments, and questions from Well Actually guys.
But we haven't given us any yet.
They haven't given us any yet, so I don't know what you guys are doing out there, but it's spending not enough time on Twitter. So jump on Twitter, check us out on Facebook. We're on Twitter at LGGPod, or you can subscribe to us on iTunes, Stitcher, Podbean, all the places where people who listen to podcasts get podcasts to listen to. Ask us questions, give us suggestions, leave us comments, and most importantly, if you like this podcast, leave us reviews. If you don't.
Yeah, please go back in time. If you don't like it, go back forward wherever you came from.
All right, that's all I think we've got today.
I think that's everything.
All right, thank you for listening.
The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by Lewis Rice LLC, its officers, directors, employees, agents, representatives, shareholders, and subsidiaries. None of the content should be considered legal advice. As always, consult a lawyer. This podcast was produced and recorded at Cool Fire Studios in St. Louis, Missouri.